What will be shown will be obviously the slide deck and the speaker view, but of course, if you want, you're welcome to turn off your camera as well. So thank you all again for being here. I'm Representative Kate Lipper-Garabedian. I'm glad to be joined today by Chair Jeff Roy to talk to you about a bill that we've filed that we care deeply about, the Student and Educator Data Privacy Act. This law is going to be a great addition to our general laws in terms of updating our legal framework to increase transparency and protect the rights of students, their families, and educators. So I'll start by just giving a brief overview of what we're going to talk about today. So if you could go to the next slide. I'd love to introduce our three esteemed panelists who will be speaking about both the national and local lens of student data privacy. We'll then turn to a brief overview of the bill that's been filed and a little bit of the history of how we've come to this bill in this legislative session. We'll then turn it over to each of the panelists to talk about why they see this bill as so critically important for students and educators in Massachusetts. And time permitting, we'll have a chance to discuss with you any questions or thoughts you have about it. We are going to share the slide deck at the end of this session and are glad to be in touch with you afterwards about any of your impressions or thoughts. So first, let me thank our three panelists for joining us today. It has been a pleasure working with each of them, some longer than others. Our first expert will be Amelia Vance. She is the Director of Youth and Education Privacy and Senior Counsel at the Future of Privacy Forum. And I know Amelia from a previous life when I was working with school districts around the country to think about how to harness the incredible potential of education technology while still protecting our students and the other users. Then we'll turn to Steve Smith. I'm fortunate here to have Steve as my constituent in the district, but importantly for today's purposes, Steve is the Chief Information Officer of the Cambridge Public Schools and the co-founder of the Student Data Privacy Consortium. So he'll be able to talk some about what's going on here in Massachusetts on the work that he's been leading on. Likewise, Felicia Vasudevan, Felicia Vasudevan is going to talk to us about her work here in Massachusetts. Felicia is an attorney with a law firm, and one of her clients is the Education Cooperative, which has been leading on supporting school districts as they negotiate arrangements with ed tech providers where they are receiving student data. So I'm looking forward to hearing from each of you. So let's talk just briefly about this bill and what it provides for our students and their families and educators here in Massachusetts. As discussed in the bill summary that we've provided to you all, Massachusetts is one of only a handful of states that have not updated our laws to address the proliferation of digital data for students. Many of you know that I'm a former 7th grade school teacher, and I'm dating myself when I say it's been about 20 years since I was in the classroom. And at that time, when my students were creating data and records, it was on paper, and I was putting it into manila folders and pressing it into an overflowing file cabinet. Just this past year, as a parent of a 2nd grader, I watched my son log in to hybrid and remote learning during the COVID pandemic and create a data footprint on a daily basis that probably dwarfs what my 7th graders created in a full school year. So I'm mindful of how important it is for our state laws to be updated to reflect this new dynamic. And we can now join, if this bill proceeds, 45 states that have already done so. Although we're somewhat of a laggard in this space, perhaps we will benefit from the lessons learned in other states, and certainly our bill aims to capture the best in other states' approaches. So we've been able to sort of update and think about, the comprehensive approach we'd like to take. So you'll see that the bill would update Chapter 71 of the general laws by adding 4 new sections. And just very briefly, I'll describe each of the sections. So the first one, which is almost a third of the bill, is defining key terms, because as any good attorney knows, the way that we describe terms is really critically important for then how we implement a law. So we've taken the language that was modeled in the SOPIPA legislation more than a decade ago when California sort of started leading on this issue, and incorporated things we've really appreciated and liked from other states. So you'll see that there is a more targeted and comprehensive concept related to operator, to covered information, targeted information, and so forth, to make sure that we're outlining the framework that we intend to regulate through the remaining provisions of this bill. The new section 34J of Chapter 71 would aim to regulate ed tech operators. So we would establish a list of things they are prohibited from doing, really around the framework of prohibiting commercialization of private data. So you'll see provisions related to no targeted advertising based on the data that the ed tech provider is collecting by virtue of being in an arrangement with a school entity. No amassing a student profile, certainly not selling information. We'll also establish required safety practices for ed tech operators. We also, in this section of law, would establish a civil action opportunity for noncompliance and empower the commissioner of DESE to bar operators for a period of time for significant noncompliance. The third section of the bill would establish a section 34K of Chapter 71. This is about the intersection in which the educational entity like a school district and an ed tech operator are entering into an agreement, a formal contract, a click wrap, or so forth, and just establish the types of language and provisions that need to be in that agreement around who owns the data, who can access that data, what happens if there is a security breach, what kind of notification and remedies are necessary, when data should be destroyed and no longer accessible. Finally, the last section addresses implementation of this bill. So that's where we establish responsibilities for DESE and for educational entities. Among the ways in which we'll empower our public actors include asking the Board of Elementary and Secondary Education to regulate in this space, having the commissioner select a chief privacy officer, ensuring that every educational entity, like a district, establishes or identifies a person who is thinking about data privacy as part of his or her professional portfolio, and ensuring that families have information about what type of data is being collected and the operators with whom the entity is engaged. This certainly came front of mind for me, and this is a provision that is in other state laws around the country, when I realized that I really didn't have any sense of whose Harrison's data was being collected by. Here I am, somebody who's actually sort of attuned to this issue and realized that I didn't know. So I think this would be really promising for families to be engaged in the educational experience. So essentially, next slide, the bill is sort of founded on these two pillars around operator requirements. What are we expecting of our ed tech providers? And then what the public actors are responsible for ensuring at the same time. Next slide. And again, I've sort of touched on this, the different stakeholders involved in the act. I would note, by way of an example in which we've learned from the other states, when we define districts in that first section, we also include their preschools that are operated by public school districts, because of course, student data isn't just starting to be collected in a digital form when you enter kindergarten, that may be happening even sooner. And finally, I'll just note that the bill also acknowledges, and this is on the next slide, also acknowledges that there are important considerations and ways that data should be used, and can really empower educators and their students to take advantage of the full range of potential for ed tech. So by way of example, the second bullet here, we note that we certainly are not attempting to prohibit operators from employing the data that they collect to think about customized student learning. So by just way of an example, if a math teacher is employing a math software app or solution to really assist students with mastering certain content, and the software enables it to sort of identify perhaps a deficit, a place where a student really needs to dig a little deeper to fully master the concept, we would want the software provider to be able to offer another module in that space. I think, as a teacher, I would love to have had access to some of the things that are available now that really create an engaging and successful learning environment for students. Finally, before I turn it over to the chair, I also wanted to just note within our definition of covered information, again, in that first provision, not only are we addressing and referring to student information, that personal data that's so critical to remain secure and private, we're also including a lot of educator data because our educators, our teachers, and folks in the school system we're often also engaging with ed tech providers to collect data to help support their craft and professional development. And we want to ensure that they also have that data protected. So that's a brief summary of the bill. Thank you so much for listening. Let Chair Roy talk a little bit about his leadership in this area, and then we'll turn over to the panelists.
Great. Well, thank you, Rep. Lipper-Garabedian. It's been a treat to work alongside you on this particular bill. I served, before I got into the House of Representatives, I was a school committee person for 10 years. I'm a parent of 3, and my last child exited college in 2018. So over those years, I've certainly witnessed the technological revolutions that's happened in our schools. And I kind of chuckled, Kate, when you were talking about teaching in the 7th grade. I go back to the 70s when we didn't even have computers in the schools. And my first introduction to a computer was using IBM punch cards. And I'm not sure anybody on this call even knows what I'm talking about. But student records and tests and homework assignments have gone from the page to the screen, and this has brought a wide range of online services and technologies into the classroom. And that has led to the collection of massive amounts of sensitive data about students by the companies who provide these services. And that's really what led me to file the first iteration of the bill back in 2015 and in subsequent sessions. I've sat down with and worked with school groups. I've worked with technology professionals to try to craft a bill, using the model SOPIPA bill that has been around the United States for several years, but building on that particular piece of legislation and trying to craft something that addresses the myriad of issues that come up. And I will say that our experience with remote learning certainly exemplified some continued gaps that we see out there. And, that's why I think, having you, Kate, as a parent who's dealing with this right now in your own home, and your background, education, and experience as a lawyer in this field is really crafted a piece of legislation I think that we can all be proud of. Just a couple of things that I'd like to point out. The existing laws like FERPA have serious gaps that allow operators to use all the available student data that they collect for commercial purposes that are unrelated to education. And it's sensitive type of information, and we need to get a handle on that. Among the other problems with FERPA is that it only applies to educational institutions. It does not apply to tech companies, and the lone sanction is the removal of all federal funding from an educational institution, and that's draconian, so draconian it's never been levied. So the data governed by FERPA, that's personally identifiable information, otherwise known as PII, it does not cover a wide range of data that tech companies may collect about students. And so we're seeking to address that through this legislation, recognizing that FERPA has simply not kept pace with the technology and is out of date. The technology industry, I will say, is on board to support a uniform model, and they've come around to support a bill that would apply directly to educational technology companies and strengthen the privacy protections for student data and ban certain commercial practices that have no place in the classroom. And I will observe that many companies have recognized the need to protect data, and over 300 of them already have signed on to the Student Privacy Pledge. But that pledge is nothing but a promise and has no enforcement mechanism. And this legislation gives teeth to the pledge and gets all companies on board. And finally, I'll say that student data should be used to improve education and help kids learn. No doubt about that. but it should not be used for commercial purposes like targeted advertising or creating non-educational profiles that profit businesses and have no relation to education. And that's why I'm happy that we can have this conversation today. And at this point, I'd love to turn it over to Amelia from the Future of Privacy Forum, which brings together industry, academics, consumer advocates, and other thought leaders to explore the challenges posed by technological innovation and develop privacy protections, ethical norms, and workable business practices through research, publications, educational meetings, expert testimony, and other related activities. FPF works with organizations and governments to shape best practices and policies in the United States and globally. And with that, let me turn it over to our first panelist, Amelia Vance. She's the Director of Youth and Education and Privacy and Senior Counsel for FPF. Amelia, it's all yours.
Thrilled to be here, and thank you so much for inviting me to present on what we've been seeing across the country on student privacy and how this bill will sort of fit into that broader landscape. So if we want to go to the next slide here, I want to start by talking about, as has been mentioned, the many ways that data and technology have helped students, the possibilities that have been opened up most recently and obviously with the ability to continue remote education related to the pandemic, but also for community building, identity exploration, civic and political participation, to play, creative expression. There's a lot of good things that are enabled here. And so the goal that I have at my organization and my work is, how do we put privacy guardrails around these things to get the most benefit to students and also make sure that their privacy is protected. Before we talk about the national landscape, on the next slide, I have a list of risks to students. So here are some of the common arguments, the common concerns that we see that have led to all of the laws on student privacy across the country. Whether it be about safety, as a stranger or someone dangerous able to communicate with my child or learn where my child lives, concerns about over collection or over surveillance, how much information is being collected about children and is it really necessary? Concerns about a permanent record, will my child's mistakes be recorded forever? Concerns about loss of opportunity, what information will be used and how will it be used to determine which opportunities my child doesn't have access to? Equity concerns. We know that a lot of data is biased, that algorithms are as biased or not as the people building them. And so what do we do if the information is biased, if it is used in an inequitable way, whether implicitly or explicitly? And what if a parent or a child can't or don't have access to the information or technology? How does that disadvantage them? There are also concerns about age inappropriate content. Is there content that isn't appropriate that can be accessed either developmentally or just things that shouldn't be accessed in school? Is there social harm? Could my child be cyberbullied or stigmatized by other students, by people in general, by their teacher or others? And then commercialization. Are companies selling my child's data or targeting advertising in them, which probably should not be happening within the four walls of the school? We need to define student privacy. And so when we're defining it with that basis of what these risks are, student data privacy, as we define it, refers to the responsible, ethical, and equitable collection, use, sharing, and protection of student data. Now, there are several laws that govern this. As mentioned, FERPA, the Family Educational Rights and Privacy Act, passed in the 1970s, a little out of date. It had two main goals, though, which are evergreen here. It guaranteed parents and eligible students, usually those over the age of 18, access to their child's education records and privacy. The purpose of preventing unauthorized disclosure of educational records without consent or with very specific safeguards. However, as we go to the next slide, this all has a caveat. FERPA today is often unclear and almost impossible for districts to navigate without significant expert assistance. While we have seen guidance from the Department of Education on how FERPA applies to education technology providers, third parties in general, as mentioned, FERPA is primarily aimed at districts. And so where there's a stick, that stick is aimed at the districts and not really at those companies. And you have to go about 5 different places to actually understand how FERPA applies, which, as you can imagine, with these 16,000 districts across the US, is pretty impossible to do. So it's very essential that we have legislation that clearly spells out what the obligations are of districts, of companies, and state education agencies. On the next slide, you can see we've had a massive change in student privacy. So just since 2013, 45 states have introduced and passed new student privacy laws. This has been well over 130 new laws across the country. And all 50 states have introduced at least one piece of student privacy legislation since 2013. Only 5 states haven't yet passed something, but several of those states, Wisconsin, Alabama, have specifically had non-legislative ways of governing their student privacy. So we have seen some movement there, just not a law out of the legislature that's passed. These laws can take a couple of approaches. If we go to the next slide, first want to mention, we do have a list of the various state student privacy laws on the website I run if you'd like to take a look. So on our next slide, the laws have generally fallen into one of 2 buckets. One is laws that are based on FERPA and sort of building off of that. So it's focused on what should the school do, what should the district do, what should the state education agency do. And it requires sometimes a shorter turnaround in which the school district has to get information back to parents or students when they request it. It often requires, as does this bill, transparency, posting of third-party vendors or of contracts or just what the data privacy policies are for the district. It often requires putting someone in charge at the state or district level. And it, in general, tries to make it much clearer, both for those who have to follow the law and for parents and students, exactly what they are supposed to do. So everybody is on the same page and doesn't require an expert to actually figure that out. The second type of law, which is what this bill is primarily built around, is based on SOPIPA, a law that was passed in California in 2014. That law was the first of many adopted in about 30 states now that directly govern education technology companies. And as in this bill, restricted targeted advertising, selling data, explicitly noting exactly what contractual provisions might have to be in contracts between the school and a company, and really giving districts some leverage, some ability to say, you have to do this. This is the law, as they are dealing with trying to make sure that their students' information is kept safe, especially important in an area like education, which is so highly regulated. If we go to the next slide, we have several states, districts that have been exemplars that Massachusetts is fortunate enough to be able to build upon. So we have, for example, Utah, which has the best student privacy structure likely in the country, which includes training, funding, and resources provided to districts. Several staffers at the state level who support districts in their work, as well as specific provisions dealing with vendors. You have some great resources on Wisconsin's website. Colorado has fabulous model policies. Michigan has some great FAQs. Raytown Quality Schools in Missouri has perhaps the best data governance policy, or certainly at least the most widely used across the country. The nice thing about Massachusetts introducing this bill now is that we are able to build upon the many fabulous examples of what has worked and what hasn't worked across the country. So on this next slide, you'll see that in addition to exemplars, we also unfortunately have some unintended consequences. So in the desire to pass legislation to protect kids, sometimes it's gone too far and actually disadvantaged students. So Louisiana, which provided jail time and fines, even if there was a mistake made to teachers and other school staff and pretty much anyone who shared student information without opting consent, had an incredibly hard time dealing with the student privacy law that was passed, I believe, in 2014, and ended up having to amend that law a few times over the past couple of years because it restricted so much. And in one case, even kept some students from being referred to the state scholarship fund because their parents hadn't opted in to having that information shared. Similarly, we've seen problems in New Hampshire, for example, where you had classroom recordings limited, disadvantaging special education students who needed that as part of their IEPs. We've seen states that have had to withhold high school graduation rates because of too restrictive bills. Technology vendors that just have stopped playing ball in certain states like Connecticut because the law is so strict that it is very difficult for many of them to engage. It's important to get the right balance here. It's incredibly hard to do, but the good news is, unlike many of the states who are introducing this earlier, you're able to say not only is Massachusetts doing many of the things in this bill, but they already have to follow these things in other states. And you have a lot more leverage to be able to make sure that vendors don't just abandon Massachusetts, but instead are pressed to make sure that they end up truly protecting student information if they're going to engage in this market. On the next slide, I want to mention that you don't just see amazing examples outside of the state. Part of the reason I think that it has taken Massachusetts this long to pull something together at the state is because you've had such phenomenal, amazing, nationally aware work done by Steve Smith, primarily, who you're about to hear from Cambridge Public Schools, through the Student Data Privacy Consortium, which he founded. And as you can see, you already have 160 of Massachusetts districts participating with over 7,000 agreements with vendors so far as of when I pulled this up yesterday that they have done. Districts have really been leading the way here. And I think, as Steve will talk about, this bill can help make that even easier and bring even more districts on board and make sure that all of them have the capacity, the support from the state to do this well. On the next slide, before I pass things to Steve, just wanted to mention that we have several resources if you'd like more information, from a policymaker's guide to student privacy to COVID-related resources, communications toolkit, all on the website we run, Student Privacy Compass, which primarily provides resources to schools, but also to several other audiences. So with that, I'm going to go ahead and toss things over to Steve.
Thank you, Amelia. It's always a pleasure to be on panels with you, as we have over the years. And thank you, Representative Kate, Representative Roy, for inviting me today to speak about the bill. I think you're going to hear a lot of the same themes and messages coming from the three panelists today. You'll hear FERPA mentioned over and over again, but I think it's good to hear probably from the different perspectives. So, as a Massachusetts district, I want to try to convey to you what it's like at the district level to address student data privacy today. And first, I want to start with just a little background about myself and how we got to the point where we are today. I came to Cambridge 14 years ago. The time has flown by, but when I came 14 years ago, some members of the community were already asking about their children's data going to providers in the cloud, and what were we doing to ensure that data wasn't being misused. So back then, we started developing processes and procedures internally to Cambridge to to get a handle on that data and ensure that providers were not misusing the data we were sharing with them. And through that process, came to realize that this was obviously an issue bigger than just Cambridge, and it needed to kind of pool resources of districts and vendors. And about 7 years ago, founded the Student Data Privacy Consortium, which is a national nonprofit addressing student data privacy. And I'll mention it a little more as we go into the slides. But really, I wanted to talk about, again, from the district level, our responsibilities to protect that student data, not only just, ethically, it's a good, the reasons to save it, but legally, those laws listed up there, FERPA, you've heard about over and over again, PPRA, SIPA, COPPA, HIPAA, and Massachusetts student record laws are the ones that we have to pay attention to as a Massachusetts district. Most of these put the burdens directly on schools, not on the vendors. Even though COPPA is a law directed towards online providers from the Federal Trade Commission, when it comes to implementing ed tech products, that burden is often pushed back on the districts to vet the products and consent on behalf of the parents. So it still falls upon the districts to ensure that the data is not being improperly used. So you've heard a number of times that FERPA is a 45-year-old law, not written for today's online world. Both Representative Roy and Kate gave examples of when they either worked in school or were in school. The records when FERPA was written, were paper records, and it was never intended for the online world that we're dealing with today. Part of the issue comes in interpreting how to apply that 45-year-old law to today's world. At the highest level, FERPA is telling districts that we cannot share data outside of the district without parental consent. But if you could imagine, with all the applications that are used in the classroom today, obtaining parental consent for every app and keeping track of it and which students have agreed to which apps and which not, it's unattainable and unmanageable. So the common practice today is to leverage what's known as the school official exception in FERPA, which allows a district to identify a third party as a school official for the purpose of providing services that the school district would normally provide but do not have the resources to. And then there's parameters around that school official exception in FERPA that basically say that the districts have to have control over those third parties. And the way that districts are doing that today is through these data privacy agreements that have a lot of the provisions that Representative Kate was talking about in this law placed upon the districts through these data privacy agreements that are signed. And if you think of the majority of districts across the state, this is a huge lift for districts to take on, to manage all the applications, find out which data is being shared with which applications, have data privacy agreements in place before they're using those applications. And a lot of districts don't have the capacity to do all that. So next slide, please. So today, COVID has definitely had an impact on awareness of this issue. But even prior to COVID, districts across the state were using hundreds, if not thousands, of applications every day in the classrooms. I think COVID really drew attention to it as people started to see their children at home using these applications. And of course, every child was now using these applications at home. So it definitely raised the awareness. We saw a lot of districts jumping onto the resources of the Student Data Privacy Consortium as COVID launched about a year ago now, or a little more than a year ago, over the summer of 2020. But still the burden remained on the school districts. And with everything else going on, it was a huge burden on the districts as they're onboarding these new applications and rolling out to all students to ensure that data is being protected. Now you can see I put 158 districts because when I looked at it on Friday, that's how many districts had signed up. And 2 more have signed up over the weekend. So we're already building more awareness. There's, Amelia noticed there are 160 districts that have joined the consortium and are leveraging those kind of resources. And probably the primary one is a model data privacy agreement, as well as the mechanisms for executing that with the vendors. So Amelia had mentioned the numbers, like over 7,000 data privacy agreements that were signed by Massachusetts districts and vendors through the consortium. And those DPAs, first of all, establish the school official exception, making that official relationship between the district and the vendor to be able to share the needed data. And then establish clear expectations about what that data can and cannot be used for. Basically, we want to make sure that the data is only used to provide the service that we're hiring that vendor for. And then there's a number of other provisions in there, such as, establishing expectations about what security measures are going to be in place to protect the data, expectations about advertising, et cetera. There's a number of different provisions. So the consortium, now it's been around for 7 years or so, is has members in more than half of the states across the country, and last year launched a national data privacy agreement that is a model instrument that can be used across the country, and yet still add on the state-specific requirements for those states that have laws. It's still obviously up to districts today to do this on their own. And as Amelia mentioned, there's a variety of different models in different states. A few states provide little or no support. Many states have legislation and some coordinated resources for the state, but few, like Amelia pointed out, Utah, have well-established state-administrated student data privacy programs. But with less than 50% of the districts in Massachusetts currently participating in the SDPC, I worry about the other 50%. What are they doing? Are they paying any attention to the apps that are being vetted and are being onboarded, and are they vetting them in some way? And this law would definitely draw attention to that and provide resources, et cetera. So the next slide, from my perspective, summarizes the impact. Like I just said, draw attention to student data privacy in all the districts across the Commonwealth, and provide much needed guidance and assistance to districts around how to protect their data. Establish clear protocols protecting student data in Massachusetts, and especially establish clear expectations for online providers to protect student data, as opposed to the districts having to place that on the providers. And then lastly, help shift some of the burden for ensuring Massachusetts data is protected to the online providers, not just on the school districts. So that's the summary of from a district's perspective. And now I'd like to turn it over to Felicia Vasudevan, who is an attorney that is representing the Education Cooperative, who is helping operationalize the SDPC in the state of Massachusetts, and has a tremendous experience in dealing with the negotiating of data privacy agreements and the day-to-day issues that vendors and districts are dealing with.
Thanks, Steve.
Yep.
Steve and I talk on a weekly basis, so I appreciate the warm introduction. So good afternoon, everyone. My name is Felicia Vasudevan. I'm an attorney. I work with the Education Cooperative, which is a collaborative in Massachusetts. It has 16 member districts, and the work that the collaborative has done really started with concerns from the 16 member districts and Steve. Steve's been with the collaborative doing some of this work from the beginning as part of his Massachusetts work. And there was a concern a couple years ago, maybe even 5 years ago now, about protecting student data privacy in these 16 districts. And it was really hard for school districts, as Steve said, to do this one-off, to get data privacy agreements with vendors, because vendors wouldn't want to negotiate with one school district. It wasn't worth it to them to have these one-off agreements. And so the 16 school districts came together and decided that they wanted to jointly start to negotiate data privacy agreements with vendors. And through that, it it grew. And so now, if we can go to the next slide. So now the collaborative represents 103 districts in Massachusetts negotiating data privacy agreements with vendors. It also does the work for New Hampshire districts, Maine districts, and Rhode Island districts. Before we were negotiating individual state-specific data privacy agreements. Since moving to the national DPA that Steve talked about, all 103 Massachusetts districts are using the national DPA, and we're negotiating one data privacy agreement for those 4 states. And that has really given us a lot of leverage because when we're working with vendors, we're using the national DPA and we are representing 4 states. So we have a lot of power in negotiating with the vendors because we have the group of states together. And so we have 841 signed DPAs that Massachusetts districts initiated. So those are just the ones that Massachusetts districts initiated, not the ones that Rhode Island, New Hampshire, and Maine have initiated. And one of the things about the national DPA is there's something called Exhibit E. And that's just a page in the national data privacy agreement where once a vendor signs with one school district, any other school district can sign on without having to renegotiate. And so that's called Exhibit E. So we have 6,800 Exhibit Es. So you can see how many districts have sort of signed on to these different data privacy agreements for a total of 7,668 data privacy agreements amongst our states. We want to go to the next slide. And so we've really seen the need for these data privacy agreements even before COVID. We were doing this work before COVID, but obviously once COVID hit and everyone was home, everything was online. Every school was using digital tools. And there was this increased need to make sure we were protecting student data privacy on behalf of all of our districts. And districts needed to have this joint effort to be able to negotiate with vendors. And their question, as Steve and Amelia both said, is what were companies doing with this student data? Are they protecting student data? Are they making sure that they're not using it for targeting and advertising? Are they agreeing that the student data belongs to the school district, not to them, so that they can't use it how they see fit? Are we sort of, as part of the data privacy agreement, limiting how the data can be used, that it can only be used to provide the services, not for other purposes? Can we go to the next slide, please? And so these are sort of, different slides of different things that have come up in the next 3 slides of maybe not Facebook, but YouTube schools are using, Google, people are using. Concerns have been raised about these different entities and how they're using student data, which is why this privacy bill is so important, is to have, we've been doing the work of negotiating data privacy agreements. But so we represent these 4 states. Maine and New Hampshire have very robust student data privacy laws. Rhode Island, not as much. Massachusetts hasn't updated its student data privacy law. I think the regulations where you really see the outline of our student data privacy laws, when I went to look last night, were last updated in 2006, the student records regulations. So it's been over 10 years since there's been any updates to student records laws in Massachusetts. And back in 2006, the changes weren't about sort of student data. And so when I negotiate these agreements with vendors, they will often say to me, like, what is the law that you're citing for why, you don't want this to happen or don't want this to happen to the student's data? For Maine and New Hampshire, I can point to statutes that prohibit how data is going to be used. There's not similar protections for Massachusetts and Rhode Island that I can point to if a vendor's asking, what is the basis for why you're asking this? And so I, as an attorney, have to explain, like, citing to FERPA and Mass Student Records Regulations, a more like step process about why I believe they can't use the data, as opposed to having something that's clearly in a statute about why they can't use it. And as Rep. Lipper-Garabedian said, we all live by attorneys by definitions and explicit language in statutes. And so without sort of that language, you can get into a battle about what does this ambiguous provision mean? Is your interpretation right? Is my interpretation right? And so to the extent we can have a data privacy bill that's clear, it's going to simplify those discussions. And so this is sort of a summary of what other people have said. We have to make sure that companies aren't selling student information. That's why these DPAs, these data privacy agreements, are so important that, if there's a data breach, what's going to happen? How are we ensuring that student data is being protected? Next slide, please. And so Steve already went through the school official exemption. This is how we have been. And in Massachusetts, there's a similar sort of school official exemption that people have to have a legitimate interest in the information. And we have to sort of disclose who we are providing the information to under the school official exemption. It should be part of people's annual notice. And so to the extent we're using a vendor, they are considered to be a school official, but then it becomes unclear under the current structure, like, what does that mean? So, and that's where the data privacy agreements really try to do. Next slide, please. And so to the extent we can update the statute to have real clarity in terms of how data should be used for both teacher and student data. And so I know that's one piece that hasn't really been talked about. Up north in New Hampshire, their bill does cover educator data. And I think that is a good addition to this bill. A lot of the bills, like Maine, is focused on student data, but educator data is being shared as part of this information too. When an educator logs in and creates an account, their information is being shared. And so protecting educator data is important too, in terms of ensuring that information is kept secure. And so these are more details beyond what sort of Steve talked about in terms of how our current DPA. So when we were negotiating, as Steve said, the national DPA allows states to add state-specific provisions. And so our Massachusetts DPA currently has all the elements of the national DPA. It also requires, unlike the national DPA, our state-specific exhibits have criminal background checks for employees that have direct access to students as part of the state-specific exhibits. The New Hampshire, as part of our quad state, has minimum data security requirements that New Hampshire law requires. And I know that this bill will also seeks to have minimum data security requirements. It also requires notification in the event of a breach. One of the things that often comes up is there's state laws about data breach, but that only covers like if there's a social security number or other highly sensitive data where there's a data breach. It doesn't cover a lot of the student record information that is currently being turned over. And so the national DPA has a data breach provision. So even if it's not that highly sensitive information, the school district gets notice so they can make sure that they help to address and mitigate any damage from a data breach. And it's a contract that make sure that the school district can hold vendors accountable. But as Representative Roy said, that's a contract. To the extent we can have a bill that adds teeth to what's in the contract, that's an added layer of protection. And then we have a lot of success in getting data privacy agreements. I forget who said it on the panel, but vendors want to enter into, it may have been Representative Roy, vendors want to do this. They want to protect student data privacy. If they are in the ed space, they want to make sure that they are good partners with school districts and good partners with families and students. So it's a handful of vendors that won't sign a data privacy agreement that are in the ed tech space. And some of them won't sell because they're not doing things that we feel that they should be doing with student data. There have been some vendors up in New Hampshire who can't meet the minimum data security standards that New Hampshire adopted. And so they can't sign the agreement for New Hampshire. And then there are some companies who are just too small to be able to go through and sort of meet these standards. But most vendors are able to sign a DPA and work through these issues. And I think that's it for me. So I know that gives us a little bit of time for questions if people have questions.
Thank you all so much, Amelia, Steve, and Felicia. That was really informative. And I know we're all benefiting from sort of taking a look at the bill within the context of what other states are doing around the country, as well as what's being led on right here in Massachusetts. Your presentations reinforced for me, not only does H127 build from really critical models that we've seen in other state statutes, So we're able to sort of cream from the top and select, the most forward thinking and promising practices elsewhere. But we're also going to be able to really lean on some of the local leadership that's happening here in Massachusetts. I think, for example, of the provisions related to DESE's responsibilities here, and so far as we'd ask DESE to develop model data privacy agreements. Well, we already have them here. So it may be that DESE simply sort of raises up what's already happening with the consortium, for example, and adopts that as a statewide model to reach those districts that are not participating currently in your various enterprises. So I don't know if anyone who's, or I'll turn it over to Chair Roy for any thoughts that you have. And of course, if there are attendees here who are interested and or have any questions, we're happy to hear from you in our remaining time.
Kate, the only thing I'd like to add at this point is just to let folks know that a bill similar did get reported favorably out of the Education Committee in the last session and looked like it was on the cusp of moving. But then, if you're all aware, we got hit by a pandemic and the priorities changed. So the pandemic did give us, as was mentioned quite frequently during this program, gave us an opportunity to revisit some new issues that had come up during the pandemic with the remote learning. So I think we have a solid piece of legislation here, and it is certainly our hope that we can get it over the goal line in this particular session. So would love to hear any questions, comments, or thoughts that folks have. Otherwise, we would urge you to get on board with us and co-sponsor the legislation and testify in support of the bill when it does get taken up by the Education Committee again.
So it looks like we have satisfied your curiosity and you have all the information that you need. But of course, you may come up with some other questions or impressions following our time together today. You have our contact information here in the slide deck. Of course, we will also be sharing it out to everyone who's registered. We're truly grateful for your time and your thought partnership on this issue, and we would love to have your support on H127 moving forward. So again, thank you to our wonderful panelists for your time and attention, and to everyone else, please be well and best to you and yours. Have a great rest of the day.